Uma voz. Boa noite. Boa noite. Boa noite. Boa noite.
Hum. Mm, mm.
Hi, everyone. Hi, everyone. I still have a couple of people tuning in. Remember, I said on Instagram Live, you can change your profile name if you don't want your name to appear, and keep your camera off or take your picture down if you don't want those things to be shown. I am excited to get started. I am going to kind of monitor the chat as we go along and see if there are questions that you guys would like me to address. And then I also will take a couple of breaks for a Q&A to give you all some time if you want as we're going through the materials. So with all of that said, let's go ahead and get started. I am hoping that doing it the way that I am doing it is going to work. We will see. So this course that we are doing today is parenting plans in Florida. Specifically, Nazarena and I are Florida family attorneys. So this really is only relevant to cases or families that are located in Florida, or that the child is a resident of Florida and Florida has jurisdiction over that child, which we'll talk a little bit about. So there is so much information to go through regarding parenting plans. This is certainly not comprehensive by any means. This is kind of like an overview, really specifically more focused on not Florida law around custody and time sharing and decision making, but more the parenting plan itself. So Nazarena and I, as I said, are attorneys. I also have a background in marriage and family therapy. We're both mediators, we're guardian ad litems. We've been practicing family law together for 15 years on and off. And we have recently started our new business, Do It Yourself Legal, really because we have just seen so many times over so many years people that attempt to navigate their case on their own and get it wrong. And one of the places that we see that quite a bit is parenting plans. I just had a consultation today with a guy about a parenting plan. I thought, I was hoping I would have time to actually redact that parenting plan to show it to you guys, because it's a really good example of how doing it yourself just based on the Supreme Court form and not knowing more, doing more than that can really cause a lot of problems. So, Nazarena and I, through Do It Yourself Legal and Family Matters, we do mediation where we can meet with both parents together and help you build a parenting plan in the capacity of a mediator. In that position, we are not, my little presentation kind of went awry down here, but I'll fix it. In that instance, as a mediator, we're not there to give anybody legal advice. We really instead are there to help you guys navigate through what is going on with this crazy presentation. Let's see. This is like one of the Canva presentations, and for some reason it is going wild. There we go. So as a mediator, we sit down, we don't give legal advice. We help you think about the things you need to think about and put the parenting plan together, as well as other things that go on with a divorce. But this specifically is about parenting plans. Secondly, we offer like limited representation where you can hire us just to give you advice and counsel, help you think about things you need to think about, or help you prepare the document, but not file a notice of appearance and not be an attorney for you in the case. And then finally, we can do it yourself coaching, which we do through video education like this, as well as one-on-one coaching if that's what you need about how to do it yourself, or in this instance, like how to build a parenting plan. So here we go again. I'm gonna have to take a second. You guys, give me 1 second here. Present. No? Let me stop sharing for a second and see if I can figure this out. Let me stop my recording. Sorry, everybody, patience. Sorry, guys. All right, let's just try it this way. Also have other people coming in, so. What in the heck? Why? I never have these problems. Nazarena, are you here?
Okay.
My computer is like not letting me share my screen. So I'm gonna make you host for just a second and sign off.
Okay.
And I'm done.
Okay, that's fine.
Everybody hold on. Back. I'm back. Sorry about that. Let's see if it is going to work now. I am hoping that it does. All right. So, parenting plans in Florida. Nazarena and I can help in a variety of different ways with getting them together. And a parenting plan at the end of the day is a contract, but it's also required under Florida law, and it's outlined in Chapter 61.13. And basically, there is a Supreme Court form that we're going to go over that talks about parenting plans, and is the parenting plan form that can be used. But what the statute says is that it really is just a document that has to describe in detail the tasks that are associated with raising the child, time sharing schedules, designate who's going to be responsible for certain things, and give communication details, as well as outline the major matters related to parenting. So for all of those reasons, the Supreme Court has created this form that can be used. However, it's not required that you use that form. You can use other forms if you want, and you don't have to use any form. However, a parenting plan is only a contract. It is not a court order. So until it's ratified by a judge, it's just a contract between the two of you, and there's really no way to enforce it. So once a parenting plan is agreed upon by the parties, it has to be submitted to the court, and you can do that through an agreed order, or you can do that through a final judgment also. But both of those get submitted to the court. This is just the craziest presentation I've ever seen in my life. Both of those get submitted to the court and ratified by the judge. The judge also has the ability to not ratify a parenting plan if they do not think that it's going to be in the best interest of the child. So the parenting plan formats, there's really like three main places that you're going to get it from. There's software programs that will build a parenting plan for you, like Custody Exchange or Rocket Lawyer. That's examples. There's a lot of them. There's also the Supreme Court form, which we're going to go through. And then as legal professionals, we kind of have our own forms with our own added custom provisions that we like and use a lot, or that we select from depending upon the case. So the Supreme Court form, which is available on the internet very easily, and if you go to the Supreme Court form's website for Florida, the parenting plan is there. And this is what it looks like in general. So what I'm going to do is I'm going to go through the Supreme Court form as it exists. And then as we go, I'm going to talk about what the provisions are and why they're important and what it is that you need to think about related to them. So what in the heck is happening? This is going to be so annoying. Okay. Page 1 of the parenting plan in Florida. Oh, I see now. Like if I go this way, it goes back. If I go that way, it goes right. It's just different than PowerPoint. So the parenting plan first page at the top, you'll see that it's submitted on agreement of the parties, or it's a proposed parenting plan, or it's established by the court. So if it's proposed, that means it's something that you are filing, which is what you want the court to enter in your case. Most of the time when we're talking about it as a contract, it's going to be agreed to by the parties. This form also, I guess, ostensibly could be used by a judge after a hearing to enter the parenting plan. So next up, you'll see addresses. So these addresses actually do become somewhat important later on, because the relocation statute is going to get triggered by a parent moving more than 50 miles from the place they lived at the time of filing or the previous court order. And this is where you're going to have that information. So the addresses do become important. It's also important that you have your email address on there for notifications about things. So next up, you're going to see the section about the UCCJEA, which is jurisdiction. And this section is really important that it is in a parenting plan. The language of it doesn't really get changed very often. but you will see that there is an other down there. Most of the time, you as a non-attorney are not going to be messing with this jurisdiction paragraph very much, but it is important for you to understand whether Florida has jurisdiction over your child or not. The gentleman that I was speaking to earlier today that I said had a mess of a parenting plan actually had this parenting plan entered, but Florida really never had jurisdiction. I guess no one ever questioned it, so the court just entered the parenting plan. But that's a problem because the UCCJA governs a state's ability to enter orders about the child. The UCCJA is not typically something that we can consent to. It's what gives them subject matter jurisdiction over it. And you'll also see at the top that you have a section for the children's information, and it asks for the names and date of birth. A lot of times parents do just put initials in here because this is not an order. It's not required for their full name to be here. Next up, you see parental responsibility. So parental responsibility, we're going to kind of skip and then come back to where we are. There are basically three types of parental responsibility in Florida. There's shared parental responsibility, which you see there under section 4.1 on the bottom. And then you'll see shared parental responsibility with decision-making authority. Sometimes people refer to that as ultimate decision-making in Florida. And that is sort of an in-between place between sole parental responsibility, which you see here on the next page, and shared parental responsibility. Now, having said that, let's see if it will actually let me navigate to my parental responsibility section over here, perhaps. So with parental responsibility, the court, as of last summer, now has a presumption really of that actually, I'm sorry, I got distracted on a different slide. With parental responsibility, not as of last summer, the court has for a long time held that parental responsibility is shared by both parents unless the court finds that it would be detrimental to the child for it to be shared. And that detrimental word is really important. That's the standard that the court has to find in order for them to award anything other than shared parental responsibility. So there is this caveat of shared parental responsibility with ultimate decision-making. That category really means we have to communicate and we have to discuss any major decisions. But if we're not able to agree, one or more areas, for example, education or medical, can be shared parental with ultimate decision-making, which means one parent's vote sort of trumps the other parent. Neither of these things, ultimate decision-making or sole parental responsibility, happen in Florida courts very often because it's very difficult to show that level of detriment would occur if the parents engaged in shared parental responsibility. I can give you an example for me recently where shared parental responsibility is at issue, rightfully so, where I have a parent who has obsessive compulsive disorder. He is diagnosed with this, and it is a very extreme version of it. And he is preoccupied with his children having particular illness that they do not have and have been tested by 20 plus medical professionals for this issue, and they do not have it. In that kind of a situation, continuing to allow the dad to be involved in medical decision-making would clearly be detrimental to the children because he is putting them through a very rigorous medical situation that there's no basis for. Also, domestic violence pursuant to the statute is a factor and can be considered in determining parental responsibility and whether or not shared parental is going to be detrimental to the child. So there is a rebuttable presumption that there is going to be shared parental responsibility, but there's also a rebuttable presumption that shared parental is detrimental to the child if there is a conviction of a misdemeanor or a higher degree criminal charge related to domestic violence. So most of the time, again, shared parental, we have people ask us about not having shared parental fairly frequently, about having sole parental, and it's just not something that's going to happen in very many cases at all. Okay, we've done these things. Okay, so next up on the page 3 of the parenting plan, it talks about day-to-day decisions, who's going to make day-to-day decisions. So this is a section that I think is lacking in a little bit of detail sometimes regarding day-to-day decisions, and also regarding like medical appointments, psychological appointments, dental appointments, those kinds of things. And at what point do we need to communicate about them? And at what point are they routine and day to day? Because the way that the parenting plan for the Supreme Court is written, it's just sort of vague in that area. So there are provisions that you can add into this decision-making section, and I have some examples of them at the end that are going to help clarify what it is that needs to be discussed and what is a day-to-day decision. Next, we have the section on extracurricular activities, which again, at the end of the presentation, I have some paragraphs and provisions that I think are a good idea to add in here. But one of the things that I think is really important to add is the form in the format that it comes in simply says that the cost of the extracurriculars is going to be paid by blank and blank. So typically speaking, the cost for extracurriculars, as well as any kind of non-child support cost, are shared pro rata in Florida, which means that it's based on your share of the income. But you will notice that up here they have this section about registering the child, and then it talks about must mutually agree. So a lot of people don't understand the difference between this paragraph and this paragraph, and that is because there's a little bit of ambiguity in how it's written. Register really means like sign the paperwork to actually register the child for the activity, whereas whether or not the child can participate, it needs to be mutually agreed upon. The other thing I don't like about the Supreme Court form is it says activity of the children's choice. Well, of the children's choice creates a lot of drama in the future when we're trying to determine whether it's the parent who wants the child to do the extracurricular or whether it's the child. So this entire extracurricular section I don't really love, and I will give you all an example of the extracurricular section that we use and that we like better. But if you are going to use this one, it is really important, I think, for you to kind of edit out this language about children's choice. Make sure that on the cost of extracurriculars that you are putting in that it's going to be shared pro rata, and that they are agreed upon extracurriculars that you are responsible for the cost of, not just all extracurriculars. And you also want to put something in here a lot of times relating to the schedule for the extracurriculars, and if the parent who didn't sign the child up is going to be responsible to transport them on that day or not. Finally, the last thing that pretty much always should be added in down here somewhere is a provision that says if you do need to mutually agree, that you will not unreasonably, or the other person will not unreasonably withhold their consent to the child participating. And another section on another part about extracurriculars is some language in here regarding activities that the kids are already in that those do not require additional consent. We already agree that those are happening and are going to continue to happen. So the section that is at the beginning of page 4 is related to records and getting records for the children. So the overwhelming majority of time, the way that this is written is fine. Each parent has the right to get access to the records. Each parent needs to directly contact the provider to get the records from them. But there are some instances, particularly in long distance parenting plans, that this really doesn't get the job done. There, more and more, everything is going digital and it is not so much of a problem. But if you're a parent, you know that there are still some paper forms that you get at school. And if you are a parent that lives out of state or doesn't have school day time sharing with your children, the other parent needs to be responsible to get you that information. And again, like I said on the last page, the parenting plan from the Supreme Court doesn't talk a whole lot about medical appointments. And I think medical appointments really should be addressed in here to talk about who's going to schedule them, who's going to take them, are both parents going to appear? We want to delineate who's responsible for annual visits. Like, does a sick visit require consent of the other parent? Clearly, emergency visits do not, those kinds of things that are not clearly laid out in here. The next section that you're going to see is the scheduling section on the Supreme Court form, and it talks about getting the calendar for the school year. I typically say that you're going to get the calendar for the school year on or before May 1st. Sometimes I would actually like for it to be earlier, but it kind of depends on when the school releases the calendar for the year. So a lot of people, I see this written in many, many times as July. You just have to be cognizant that the school calendar here, where it's talking about that you have to obtain it, the reason for that is because a lot of the time sharing provisions that are in a parenting plan rely on the school calendar to tell you when certain time sharing events are going to happen. Again, on the kind of at the top, when we're talking about general provisions, these are some general provisions that the Supreme Court does include about how far in advance you need to make a schedule change. However, you will notice that what it doesn't say is what's going to happen if you do not give that amount of notice. So that's a provision that we usually add in, is what is the consequence if you don't give enough notice, and how is that going to be handled? Now, you will see that you could be responsible for additional child care and transportation costs that are caused by that. I think people don't really think a lot about what that means. So if it is the other parent's day to pick the child up and they don't pick them up, or they're late, or they cancel last minute, and you now need to get a babysitter or extra daycare or before care or after care, the cost of those things could be the responsibility of the other person if it was their day and they didn't give the notice that they needed to, and they didn't make accommodations for the kids. So then we have time sharing schedules and time sharing examples. So let me go to time sharing. So as of last summer, this is what I started to say earlier, our time sharing has shifted, and there is now a presumption of equal time sharing in Florida. And in order for you to overcome that presumption, you have to show that equal time sharing is not in the best interest of the child. So the time sharing schedules can really be anything that you can imagine or make up. But there's only 7 days in a week. There's only 12 months in a year. There's just so many ways that you can cut time up especially to land at 50-50. When you have a schedule where one parent has less than 50-50, there's a little bit more wiggle room in terms of how the schedule gets laid out. But the typical schedules that we use in Florida are the two that I'm showing you on the screen. On the left, you'll see is a 5-2 schedule. And on the right, you will see is a 2-2-3 schedule. So the 2-2-3 schedule basically is one Monday and Tuesday, mom would have, and then dad Wednesday, Thursday, and then mom Friday, Saturday, Sunday. That's week 1. In week 2, dad would have Monday, Tuesday, mom would have Wednesday, Thursday, and dad would have Friday, Saturday, Sunday. So the benefit of a 2-2-3 schedule, and the reason we like a 2-2-3 schedule for younger children, for children, let's say 8 and under, is because it gives you frequent, consistent, short durations back and forth with each parent, which is a lot easier for younger kids to deal with. Younger kids don't do well with long periods of time away from one of the two parents. The problem with the 2-2-3 schedule is there's not a lot of consistency. If the child has gymnastics on Tuesday, one week mom's going to take the child, the next week dad's going to take the child, vice versa. So there's a little bit of a lack of consistency, and it can also make some people feel like it's difficult to manage your schedule as a parent, although you really should be able to look an entire year out and know what your days are. With a 5-2 schedule, it's somewhat similar in that it's broken up into Monday, Tuesday, Wednesday, Thursday, and then Friday, Saturday, Sunday. But in the 5-2 schedule, the same parent ends up having Monday and Tuesday every week. So here, the mom has Monday and Tuesday every week. Dad has Wednesday and Thursday every week. And then they're alternating Friday, Saturday, Sunday. So when you have this kind of a 5-2 schedule, what ends up resulting from this is that you can see that dad has 5 days straight, and then mom has 2 days, and then dad has 2 days, and then mom has 5 days. So it results in one week you have 5 days, the next week you have 2 days, and it goes back and forth like that. Obviously, we also have a 7-7 schedule, which I'll show you on the next slide, which is the simple, easy 1 week on, 1 week off. And that is really the schedule that is recommended for older kids. Like once you're middle school, high school, the week on, week off does a lot better. And most child psychologists and therapists will tell you that that schedule is easier, especially for teenagers to deal with. These schedules here are examples of non-50-50 schedules that happen pretty frequently. And there are reasons and times that a non-50-50 schedule is what a person needs. That can be true based on people's work schedules, as well as the location, how far they live away from each other, etc. So the schedule on the left is where you have every other weekend, and then you have one day during the week that's not connected. So for example, here you can see that dad has every Wednesday and then also every other weekend. So with this kind of a schedule, there is some weekly consistency, and we're evenly dividing the weekends. The thing that I do not like about this schedule, and very rarely recommend it, is that this is a whole lot of back and forth for a child when they are at mom's on Tuesday, dad's on Wednesday, mom's on Thursday, dad on Friday. I understand parents use this. I have heard the reasons why, but for me, it's just a lot of stress to put on the kids with the back and forth between the two houses. So the alternative to that is every other weekend with a weekday that's connected. And as you can see here, I did it on Thursdays on this particular example, but you also could have done it on Monday as well. As long as it connects to the weekend, then you're going to end up having at least every other week, 4 days in a row, and then one night on the off week. And then this is just the simple 7-7 schedule. Now, what I will add to the simple 7-7 schedule is that it is under almost all circumstances, unless you have a very good co-parenting relationship, it makes the most sense for you to exchange your kids on a school day when you can simply have one parent drop them off and the other pick them up. Now, I understand that that causes some inconvenience with transporting things back and forth. But if you have a 50-50 schedule, you really should have a whole set of things for your kid at your house. I realize that doesn't always work out that way. If you have a very good co-parenting relationship and you want to exchange on a weekday, no problem. But when your relationship is not good and there is clear tension and stress between the two of you, putting your kids in a situation where they need to be present with both of you is uncomfortable for them. So if you are in a situation with your co-parenting that you do need to see each other for exchanges, you really need to think about how and where and why you can do that as cooperatively and amicably as possible, whether that is exchanging in the driveway, having the child come out, whether it's meeting in a public location, whether it is exchanging, before another spouse gets home, or whatever it is for your situation that's going to help decrease the stress for your kids. Okay, so those were some examples of the general parenting plan, time sharing schedule that people can end up with. Those schedules are pretty much followed with limited exceptions. And I'm going to show you all, like I said, at the end, some long distance plans, which clearly have a different look to them. Okay. Can someone tell me if you see a PDF on your screen or if you see my presentation? You can tell me in the chat, I suppose. Fixed it. Okay. So what you're seeing on your screen now is a sample holiday and vacation schedule that I use for my parenting plans. So I wanted to walk you through this schedule and this document rather than the Supreme Court form, because I think the Supreme Court form is terrible when it comes to holidays. So you'll see on the top that it very clearly states that this plan remains in effect unless you alternate it in writing. That's important because a lot of times people make verbal agreements that you have misunderstandings about, and what you do not want to do is spend your holiday not the way you intended or planned because there was a misunderstanding between the two of you about changing the schedule. Secondly, this document shows the holiday schedule takes precedence over vacation periods, and that vacation periods take precedence over regular time sharing. Why is that important? Because if you didn't have that, and this holiday schedule said that mom gets Easter in even years and that dad gets spring break in even years, but Easter then happens to fall on spring break, then the question is, whose time sharing is it? So this precedence language takes care of that because it tells us the holiday is the top priority, vacation periods are under that, and regular time sharing is below that. The other thing that it talks about is if there is an overlap or some kind of conflict, who is that's going to prevail in even years versus odd years. Next, you'll see that the parents will share the holidays. These are minor holidays based on the schedule that we have outlined below. And it is written to say that it'll be again at Friday at 3 p.m. and continue until 9 a.m. the following weekday. However, that can get edited to say any variety of things: school drop off, school pickup, those kinds of things, or, 6 p.m. to 10 p.m., however it is that you want to write that in. These are the holidays that typically get addressed. A lot of times people don't want to address minor holidays and they just want it to be with whoever it is the holiday falls on their time sharing, and that's fine as well. You can take out holidays that you don't want to address and just leave them blank and they'll follow the regular schedule. You will see that for me, I have some specific language about holidays down here in the bottom that I use repeatedly. 4th of July, if it ever occurs on Friday, Saturday, Sunday, or Monday, that it's going to include the weekend. If it's a Tuesday, Wednesday, Thursday, it's a one-day holiday. That's because it changes throughout the year. Halloween as well, that if it's on a school day, it's going to be for a particular period of time versus if it's on a weekend. Veterans Day, typically we also have language that talks about that it's celebrated as a one-day holiday and that it continues overnight, particularly if schools are closed. Next up, we have birthdays. I hate putting birthdays in parenting plans. I think it's a terrible idea unless you are a person who has very limited time sharing, in which case you certainly want to put birthdays in here. But if you have close to 50-50, you're going to end up with your kid 50% of the time. And it's just, to me, it's a lot of hassle. Normally, you're going to see the child either the weekend before or the weekend after. But I get it. There's some parents that are very passionate about this. They feel very strongly that they want to wake up with their child on their birthday at least every other year. And so it is a provision that can be added in. And you can also differentiate between whether it is a school day or whether it is a weekend that the birthday falls on. Easter and spring break, I tend to lump together. Whoever has Easter also has spring break because every few years they do fall on the same period of time. With Easter and with spring break as well as with Thanksgiving break, there are a variety of ways to divide it. So with spring break, either you can do either even odd with one parent getting the full break, which usually ends up being 10 overnights, or you can divide it in the middle and say whoever had the first weekend gets until Wednesday and the other parent gets through the following weekend, so your weekends stay consistent. Thanksgiving, there are a million different ways to break up because most school districts now have 10-day holidays for Thanksgiving. Some of them still have just Thursday, Friday off. So first of all, you sort of need to define whether the break for you is the entire week or whether it is simply Wednesday, Thursday, Friday, Saturday, Sunday. If it is going to be just Wednesday, Thursday, Friday, Saturday, Sunday, perhaps it just makes sense to alternate it every year. If it is the entire 10-day break, a lot of times that gets split in half as well. So one parent would get from the time school is out until Thanksgiving Day at noon, 2, whatever, and then the other parent would get from Thanksgiving Day until school goes back. That way you're splitting the day itself in half. That doesn't work if you're a family that likes to travel. And so these are the kinds of things that you really have to think about what works for your family. There is no one size fits all. So if you're a family that travels, you're probably going to want to alternate the entire break. With winter break, we have the same thing. So on my plan, there's all these different options that I kind of have, and I just delete the ones that I don't need. You can divide the break in half, splitting it on Christmas Day. That way one person gets Christmas Eve and Christmas morning. The other person gets Christmas Day and New Year's Eve and day. You also can you can divide the whole break in half, but kind of carve out. It's what we call a carve out, Christmas Eve and Christmas Day. So you can say one parent gets the first half, the other parent gets the second half. However, it doesn't matter who had the first or second half. This is what we're going to do Christmas Eve and Christmas Day. This is what we're going to do New Year's Eve and New Year's Day. And then the final option is to divide the entire winter break. That one person gets 2 whole weeks, then the other person gets 2 whole weeks. This makes sense, I think, in long distance cases, although I typically like to add that if you are a long distance parent, 1 year you would get the whole entire break, and then the next year you would get half the break, just not the part that includes the holiday that's important. And I've been talking a lot about Christmas here, but you also can do carved outs for all of the Jewish holidays, like whatever holiday falls on this winter break period of time, you can do carve outs for it. I also clearly have the Jewish holiday schedules in here, and then we come down to summer break, summer vacation. So if you have a 7-7 schedule, a 50-50 7-7 schedule, most of the time just leaving your summer break alone is fine. You just keep following the regular schedule. Unless you're a family like my family that travels extensively in the summer, and I would need more than a week at a time, in which case there's a million different ways to do it, right? You can have 3 weeks, 3 weeks, 3 weeks, and then 1 week that gets split in half at the beginning and end. You can do 2 weeks on, 2 weeks off in the summer. You also, a lot of times, if it's a long distance plan, one of the common schedules to have and for us to type up for parenting plans is that whoever the local parent is would have the first week and the last week, and the other parent would have the section in between, the 8 weeks that fall in between. That cuts down on travel cost. The other problem, though, is 8 weeks is a very long time away from one parent. So again, there's a lot of schedule options. The traditional schedule that is in most parenting plans is that each parent has 2 weeks of consecutive or non-consecutive time sharing during the summer. You exchange your dates by a particular day that you want. And if there is a conflict, so for example, I would say I want July 1st through the 15th. The other person would say, well, I want July 10th through the 20th. So then we have a conflict over some of those days. Whoever it has selection priority in that year would get the days in the event that there's a conflict. This selection priority is not in the Supreme Court form, but all lawyers put a selection priority in their parenting plans because it causes so many problems. There also are professional in-service days, days that school are closed, and you need to have provisions in there for whether those follow the regular schedule, whether those are going to be treated differently, are they going to be connected to the weekend, and we want to clarify who is responsible for childcare on those days, especially if they're an exchange day. You know, if you typically exchange your child at the end of school and you find yourself on a day where where school is not in session for some reason because it's in service or teacher planning day or whatever it may be, you need to figure out who's responsible to make sure that we have childcare on that day. Because if the exchange is normally at 3, is it the parent who was earlier in the day who would have been ending their time sharing? Is it the one who's starting their time sharing? Those are provisions you want to get clear on in putting together your parenting plan. Okay, so we now get up to page 8, and page 8 is the end of the holiday time sharing and break time sharing, and we have the section about overnights. The calculation of overnights is not an easy thing to do all the time, but it is a really important thing to do because the number that is put here on the section regarding overnights is what is going to end up impacting child support at some point. So there's a variety of different ways to calculate the overnights. The way that I calculate the overnights is to take out all of the break sections. So the 10 weeks of summer, the 2 weeks of winter break, the week of Thanksgiving, the week of spring break, and I do the math on who has what portion of those weeks in a given year or on average. So for example, if you have the whole Thanksgiving break, which is 10 overnights every other year, then your average would be 5 overnights a year for that particular break. And then I take the rest of the weeks that are in the year. So 52 minus 10 for summer, 2 for winter, 1 for spring break, 1 for Thanksgiving break. And at that point, we figure out what the week-to-week schedule is. Other parents, I have seen them literally get a 12-month calendar and write it out and count the days. However you want to get it done, you can get it done, but it is important that this is in here. Next, you're going to see the section about transportation. So transportation really, for the most part, is talking about pick up and drop off and who's going to be responsible. This also is very unique and specific to each family, but as a general rule of thumb, I do like the way that the Supreme Court set up this section, that it's either the parent beginning or the parent ending their time sharing. I think that that makes it an easy, predictable way, and that we're sharing the weight and the load. You will see then on the bottom, we start to talk about the exchange placement and what, where it is that we're going to be and how long we're going to have to wait and those kinds of issues. And you will see that there is a blank section there too, because again, the Supreme Court is not really giving us a lot of details about how long you have to wait, how much notice you need to give if you're running late, whether if you run late and you all meet somewhere, does that mean that the late parent now needs to travel to the other one's house? Transportation cost is the next section. And with transportation cost, typically, if we don't have out of state or travel provisions, this just does not get addressed. So it's in the form, but we don't use it very often for local travel. Now, the foreign or out of state travel section is important, and I have another slide on that. So I'll go over it in just a second when we get to that other slide. I also have another section related to education. But before we move on, it is important to take a look at under the education section, it talks about for school boundary purposes. This is important because if you have 50-50 time sharing, which is the presumption, there's not necessarily a presumed school for boundaries. So this very basic provision here designates mom or dad. We don't do that very often. We typically have much more extensive language about schools in our parenting plans. For example, one of the really common ones is that the child is going to attend the school where they currently go unless and until it's not available. Also, that the child is going to attend the higher rated school between the two options that the child has available. Sometimes we have provisions in here about charter schools, about private schools, about payment of private schools, about registration and applications to charter schools. The education provision that is in the Supreme Court form is definitely very highly lacking in specifics and details. And there's a balance with parenting plans where we don't want to be so specific and detailed that there's like no room for discretion or flexibility, because we want people to be flexible. But on the other hand, we also want there to be enough structure and enough predictability that you don't end up back in court. So you can see on the other side of the screen here, a travel provision that is typical to what we would have written. And it talks about, in this particular one, that either parent may travel within the United States. So that may word is important. It then says the traveling parent shall give notice. So if it had said either parent may travel with the child within the United States, provided they have the consent of the other parent, that would be different, right? So, and we do a lot of times have, rather than the parent may travel, it would be may travel with the written consent of the other parent, or may not travel without written consent of the other parent. So, and you will see there is a different out of country provision versus within the United States. Some people also add in here a state specific provision, like that you can travel within Florida without permission, just with notice. But if you are going to go out of the state of Florida, you need more than notice. You also need permission. And then just quickly to point out, you'll see here at the bottom this language about The Hague. You're not going to see that in the standard Supreme Court form, but it is important language because The Hague is an international convention that basically is where a country signs on to say that they are going to enforce and follow the laws and orders of the United States as they relate to custody. And if a country has not signed The Hague, they have not agreed to participate in the Hague Convention, then they don't necessarily need to honor or uphold the orders and agreements of the Florida courts or of courts of the United States. The next page, page 10, that we have in the Supreme Court form is designation for other legal purposes. This is a very weird provision that I think you could ask 100 attorneys and get 100 different answers about why we have it here. From my perspective and in my opinion, it is really for like federal legal purposes where you need to designate a particular address or a particular parent for benefits or assistance or something like that. Now, that doesn't mean that they're entitled to keep them. It's really like a correspondence kind of address. But I can assure you, many lawyers have many different theories about it. And it doesn't, in my opinion, from what I have seen, have a huge impact on people, one way or the other. The next section is communication, and you'll see first there's a section on communication between parents, and then you'll see that there is a section between parent and child. So when we're talking about phone calls and video calls with your kids, you are going to want to make sure that you have some specifics in your parenting plan about how these things are going to operate if this is something that is important to you. So I have here at the top an example of what our parenting plan might look like, that telephone contact is not going to be monitored or interrupted, that the child can have particular periods of time that they're going to have telephone contact, that either the child or the other parent can initiate the call. Sometimes we want different things. Sometimes we only want the child to initiate the call. Sometimes we want provision in here that says that if a parent initiates a call and the child misses it, that the child will call back within an hour. It really does, again, depend on the specific circumstances that you have, but you also have to sort of predict what might happen in the future, because perhaps the two of you are getting along now, but things shift in the future. You want enough written in that it's enforceable and that you can actually get what it is that you want out of it. I also have given you here on the bottom another example. And once I finish the presentation, you guys will be able to access this PowerPoint that has the information on it. So back to page 10 and communication. With the communication between parents, I just want to talk about that for a little bit. Now, some parents have good communication and it is not a problem at all. Other parents really have a lot of issues with communication. And so there are apps that are available and that you can use for communication purposes for co-parenting. So for example, there is like Talking Parents, there is Fair, there is Our Family Wizard. There are a lot of different options that are available. At the end of the day, what you are going to end up with when you use one of these apps is a program or an app on your phone and on your computer that works very much like text messaging. It's sort of similar to WhatsApp, where it's an app, you message back and forth in it, you can share files, you can share calendar events. And I have redacted for you guys on the screen an example of, as a lawyer, what it is we get when we need this communication for purposes of court. You can see that this is a complete record of communications. You can see the time that the parent signed up. You can see the time that they started using it. And you can see that there is a certification that it's accurate and it is a business record, which means that this information comes in as evidence very easily and the court can have access to it. The other thing that you're going to see is that there are subjects that a parent can talk about and can have answers underneath that particular subject. You also will see when a message was viewed and when it was responded to, or if it was never responded to. So here you can see in the middle of the screen that there's a new section about tax implications, whereas up here we had been talking about time sharing. And then you can see it moves on to another subject about therapy. And what you also can see is the back and forth between the parents. And I can tell you as a guardian ad litem, it is very, very, very insightful to watch how parents communicate with one another, especially when they are communicating with one another on an app that they know can be presented in court as evidence. So it's very telling for us to be able to get an idea of how people are interacting and whether or not they are interacting in the best interest of the children. So page 11, let me just make sure that I got through all of page 10 because yes, I did. Oh, at the very bottom of page 10 is the cost of electronic communication. That is the section that we typically would put cell phone cost for children in. So if you have cell phone cost or you want to address cell phone cost or who's going to maintain it, how it's, who's going to track it, all of those kinds of things that can go in there. At the top, you'll see on this page, childcare. And you will see that it says either parent may select or all providers must be agreed upon. So this is really preferential, right? It is your preference whether the two of you have to agree or whether you each get to pick your own. I can tell you, and I'm sure you can imagine, that having to agree creates many, many problems. But what you don't want to do is say that either parent can pick their own and not add additional language about what that means, exceptions, specifics, exchanging information, all of those sorts of things. On the third line here, you'll see that you have to offer the other parent an opportunity. That is called a right of first refusal. Judges hate this provision. Lawyers don't like the provision. It creates a lot of litigation, but a lot of parents like it, because it's basically saying, before you can get a babysitter for our child, you need to give me the opportunity to keep the child. And if I say no and I can't, then you can go get a babysitter. But first you need to ask me. A lot of mediators and parenting plan software will plug in 4 hours here. That is a ridiculous amount of time. You don't want to have to call the other parent if you're gone for 4 hours. That could be you going to dinner and a movie. But perhaps 12 hours, perhaps overnight, perhaps 8 hours. You also want to clarify here that this is not for like routine things like work. This is for like some kind of a special event. On the left here, you will also see temporary changes can be made, but any substantial changes have to be made through a petition for modification. There are instances where you do want to deviate from this. The standard for modifying a parenting plan is very, very high in the state of Florida. And there are a lot of times that you might want to add a think about to modify this or to tailor this provision to your needs, because the language that exists in the statute about modifications makes it very difficult for you to get a modification. Next, you're going to see the relocation section. The relocation statute says 50 miles or more from where you live, you have to file for relocation in the state of Florida. That's for the parent or the child. We alter this a lot. Shorter in a lot of instances, because 50 miles in South Florida could be a 2-hour drive. Someone could move 48 miles, not be outside of the relocation zone, and create a situation that the child has to travel for 4 or 5 hours a day. So a lot of times we limit this. Also, sometimes we have provisions that give someone advance permission to move in the future. And then finally, you'll see the dispute and conflict resolution. One of the important parts of that is that you'll see there's a difference between shall and may. The parents shall attempt to cooperate, but they may want to go back to mediation, which means you must attempt to cooperate before you file something, but you don't have to go back to mediation. You just might want to. And then you'll see other provisions down there at the bottom. Typically for us, that's where child support ends up coming into play. Child support can be in your parenting plan, but it doesn't have to be. A lot of times it can come in other agreements as well, but it's okay to add child support into your parenting plan. So now I just want to go towards the end a little bit of the presentation and talk about some of the specific things that you would want to look at for a long distance parenting plan. So you need to think about visitation schedules, travel arrangements, how the communication is going to work. You need to incorporate some flexibility into a parenting plan for kids that are going to travel, because there's a lot of factors: school schedules, cost of travel, accompanying adult. And then finally, you want to think about, the financial implications of that, but also your child's schedule, their activities, their school schedule, etc. So I gave you here just an example of what a time sharing schedule might look like in a long distance plan that has a very high amount of flexibility in it. What you probably have seen before are the more standard traditional long distance plans, which say that the out-of-town parent gets the whole summer, every other winter break, every other Thanksgiving break, long weekends, etc. This is a little bit more of a custom flexible plan that I thought I would just give for example, because it gives you an idea of how specific these things can get and how flexible we can be. There is law in our Florida statutes that says that for mental health treatment, as of the law changing, that either parent may consent to mental health treatment. That is the standard. But what it does not mean is that the two of you cannot include in your parenting plan that you do need to agree. So the standard is that you either or can go get the mental health treatment for your child, but you do have the ability to add in language that you do need to agree to it. So through here, to wrap things up today, are just some topics that are not in the Supreme Court parenting plan that you would want to think about. Specific extracurricular activities. There are certain extracurricular activities that are outrageously more expensive than others. Horseback riding, travel teams, certain things that are really expensive. If your child participates in one of those things, or you think you might want them to, that's something you may want to address. Also, dangerous activities. If you are a parent that has issues with a particular sport, you are concerned about a particular sport, You want to put provisions into your parenting plan that prohibit that or that make it to where you have to mutually agree to it. If you have very definitive feelings about vaccinations, that's something that should be addressed in here. And what kind of policies you want to follow, who you want to defer to if the two of you can't agree on these kinds of things. Again, not important for every family, but for some families, this is really, really important. Private school or charter schools. If your kids go to private school and you want them to keep going to private school, you need private school provisions in your parenting plan. If your kids go to a public school, but you want the ability to put them in private school in the event you can afford it, you need to have that provision written into your parenting plan. That is not presumed. We were in litigation last year with a client who wanted to pay for a top tier school for their child to attend. And the other parent refused, said, no, I'm not letting the child go there, even if you pay for it. I don't care if you're paying for it. I don't want the child to go there. Not saying the other parent didn't have reasons. Were they justifiable? I don't, in my opinion, no. But if you do not have language in there about it, then you may not even have the option to do that in the future. Computer and gaming restrictions. This is a very big issue with preteen and teen kids. It is great if parents can get on the same page about screen time limits and gaming limits and those kinds of things. But if you are not able to, then perhaps you want to at least have some guidelines written in. And I do see that there's some chat and Q&A going on, and so I will, can you discuss long distance holiday time sharing in detail? The other parent feels they will get the duration of all school holidays. Is this a possibility? It's still on the parent communication. That was a little while ago. Long distance. Okay, so it looks like I'm keeping up. And how easy is it to move when there is not a parenting plan in place? That is a difficult question that I can't really answer on here. You would probably want to go back and look at some of our videos that talk about relocation and moving because it is very case specific. As to the long distance parenting plan, I think I went through a lot of that. Now, back to your specific question on long distance time sharing schedules, is it that the parent who lives away is guaranteed to get all of the holidays? Absolutely not. However, I do think it is a little bit case specific, right? You want to kind of think about how much time the non-local parent has. You want to think about the reasons for the non-local parent living where they live, the background, the history, and those things also are going to play a role in determining the cost of travel, right? If you are the parent who has moved and you have taken the children with you and you have agreed to, the other parent has agreed to let you move out of the state, then you may end up carrying a little bit more of the weight, giving up a little bit more of things that are important to you because you were granted the relocation. So it is somewhat specific. But for the most part, with long distance plans, we are talking about summers, Thanksgiving, winter break, spring break, long weekends. And a lot of times with long weekends or school time, you can talk about the non-local parent coming local to spend some time with the child, to give them extra time where they travel instead of the child traveling. With the child traveling, unless it is a very short travel distance, it is much easier to do that with the break schedules. Back to provisions you want to think about. You want to think about rules on leaving kids alone. This comes up a lot. Parents have very drastically different ideas. A lot of times it's cultural. A lot of times it is very personal. And if this is something that causes a lot of concern for you, you want to put this kind of stuff in your parenting plan. The form does not talk about it. Social media. For me, social media is an important thing. Like feel very strongly about my kids not being on social media until a certain age. I certainly would want that written in because it's very, very important to me. Other people, it's not a big deal, and their kids have TikTok when they're 6 and do whatever. No judgments for those of you with kids on TikTok. I have no problems with it. I just don't want it for my children. But those are things that you need to think about and perhaps add provisions in. Cell phone rules. When are they going to get a cell phone? How are they going to be able to use a cell phone? Are we going to be able to take a cell phone away as grounding? If we do, as parents, do you still need to allow the child to contact the other parent? Cell phone rules of engagement on cell phones. And then you might also want to talk about co-parenting or mediation in the event that you and the other parent cannot agree on the parenting plan, cannot agree on decision making for your kids, so that you don't end up in litigation as quickly and you instead are working together to try to work through some of these things with a professional who can help guide you. Sleepovers and field trips. I always giggle when I get to this part because like Nazarena and I have very different opinions on this. And so if we were co-parents, we would have a lot of problems. She feels very strongly about sleepovers, very strongly about field trips, in the sense of very restrictive and conservative about them. I, on the other hand, am not at all. These are things that are personal and there's no right or wrong to them. They're just things that you need to think about for your parenting plan. Medication use. How do we feel about medication? Who are we going to defer to in the event that the two parents cannot agree on medication? If your child gets diagnosed with ADD and the psychiatrist is recommending Adderall or a stimulant, and one of you wants to do it and the other doesn't, how do we have a tiebreaker in those situations? How do we have a formula or mechanics in place to keep us out of court and to let us solve these problems with people other than judges who are better informed and able to make these sorts of decisions? The same with tutoring and grades. I cannot tell you how many times parents are arguing over whether they have to share the cost of tutoring and over one parent not having consequences for grades while the other does. Particularly with tutoring, it's very easy to say, if the child is making these grades or below, we agree that we're going to do tutoring. We agree that we'll do it up to a certain amount, but not above that. So those are things that you can incorporate into your parenting plan. Okay, so I am going to stop sharing my screen for a minute and go through the remaining questions and do a Q&A with you guys. Let's see here. How easy will it to, I've already answered that one on the Q&A. Let's go to the chat. What considerations need to be made for a parenting plan for a child that has long-term care needed? Well, I'm assuming, so to answer this question, I'm assuming we're talking about coming up with a parenting plan for a child that will eventually become an adult with a long-term disability. So once a child is an adult and is emancipated, it really switches over to a guardianship, and we're not operating under the family parenting statutes anymore. However, child support and financial support for the children or for your kids does need to be addressed in a parenting plan or in when you're going through the court case in some kind of an order. Because if you have a child that has a disability that's going to require long-term care, you want to address that in the parenting plan from a financial perspective. Any recommendations on a parenting plan for a 3-year-old special needs child on the spectrum in therapy Monday through Friday? I think Naz has already signed off at this point in time, but Naz is somewhat of our resident expert dealing with parenting plans for kids on the spectrum. Naz has a son on the spectrum. She's lived ABA therapy. She knows how all of this stuff works. She's gone through all of the things. And she's actually going to be teaching a class on parenting plans and co-parenting for kids on the spectrum. So stay tuned and look out for that coming up, because there really are a lot of specifics and things that you have to think about differently when you're dealing with a child with special needs. And anywhere on the spectrum, even just neurodivergent children in general that aren't necessarily on the ASD spectrum, there's things that we need to think about. Then I see that lived with mom in Florida and dad is out of state, and he is regaining time sharing after breathalyzer. Yeah, so there's a lot going on there and a lot to think about. There are time sharing provisions and parenting plan provisions that we think about with substance abuse. I am going to do another class on parenting plans where substance abuse is involved, because there's a lot of specifics that go into parenting plans where there's a history of substance abuse. And like I said, Naz is going to do one on kids that are on the spectrum. So when we have those kind of very specialized parenting plans, we're going to do some classes on it, but I would really recommend that you work with an attorney, either through like DIY coaching kind of an idea, or that you have an attorney prepare the parenting plan for you if there are very special needs. What do you do when a dad keeps breaking the parenting plan, barely 2 months old, returning that child late, 3 hours here and there? Is there anything you can do? I absolutely think that you want to document, you want a calendar, and you want to update it. You also want to communicate those kinds of things. I think that getting yourself on a parenting communication app like Fair Talking Parents, Our Family Wizard, can help, because that's a good way of documenting and communicating the issues. And if there are a pattern and a series of violations, at some point you're going to want to file a motion for contempt and enforcement. When you file a motion for contempt and enforcement related to parenting plan violations, it can kind of feel like you're doing it needlessly, because the question becomes like, what can the court do? Well, the court has the ability to do a lot of things, but it's not really about what they can do as much as it is about creating a record. Because if it continues to happen over time and you file enough motions for contempt and enforcement, then at that point it could become the basis for a parenting plan. I see Noel said adult child. So if it is an adult child, then you're going to move into a guardianship placement, and rather than dealing with it as a parenting plan. If one has decision making, how much discussion needs to happen with non-decision making parent before the decision to move forward? Well, if you have sole parental responsibility, not much. Now, that doesn't mean you don't have an obligation to keep them informed necessarily, but you don't have to discuss it. You don't have to take their opinions or thoughts into consideration. If you have ultimate with decision making, you do need to discuss it, but whoever has ultimate decision making ultimately gets to make the call at the end of the day. Well, guys, that is the end of my parenting plan course.